Labor Law of Cambodia, 1997, Paid Holidays, Paid Annual Leave and Special Leave. Section V, Paid Holidays, Article 161, each year, the Ministry in charge of Labor issues a Prakas, ministerial order, determining the paid holidays for workers of all enterprises. These paid holidays do not break off the length of service required to obtain paid annual leave. Nor do they reduce this type of leave. Article 162, in case the public holiday coincides with a Sunday, workers will have the following day off. Time off for holidays cannot be the reason for reducing monthly, bi-monthly, or weekly wages. Article 163, workers paid by the hour, the day, or by the amount produced shall be entitled to an indemnity equal to the wage lost as a result of holidays as defined in Article 161. This indemnity shall be paid by the employer. Article 164. In establishments or enterprises where work cannot be interrupted because of the nature of their activities requiring the workers to occupy with working during holidays, those workers shall be entitled to an indemnity in addition to wages for the work performed. The amount of this indemnity to be paid by the employer shall be set by a Prakas of the Ministry in charge of Labor. Article 165, hours lost because of holidays as indicated above can be made up according to the conditions laid down, stated, in laws in effect. The made-up hours shall be considered as normal work hours. Section 6, Paid Annual Leave, Article 166, unless there are more favorable provisions in collective agreements or individual labor contracts. All workers are entitled to paid annual leave to be given by the employer at the rate of 1.5 workdays of paid leave per month of continuous service. Any worker who has not worked for 2 continuous months is entitled, at the termination of his labor contract, to compensation for paid leave calculated in proportion to the amount of time he worked in the enterprise. For jobs that are not performed regularly throughout the year, a worker is considered to have met the condition of continuous service if he works an average of 21 days per month. The length of paid leave as stated above is increased according to the seniority of workers at the rate of 1 day per 3 years of service. Official paid holidays and sick leave are not counted as paid annual leave. Article 167, the right to use paid leave is acquired after 1 year of service. If the contract is terminated or expires before the worker has acquired the right to use his paid leave, an indemnity calculated on the basis of Article 166 above is granted to the worker. Apart from this, any collective agreement providing compensation in place of paid leave, as well as any agreement renouncing or waiving the right to paid annual leave, shall be null and void. Acceptance by the worker to defer all or part of his rights to paid leave until the termination of the contract is not considered as renunciation. Deferment of this leave cannot exceed 3 consecutive years and can only apply to leave exceeding 12 working days per year. Article 168. Before the worker departs on leave, the employer must pay him an allowance that is at least equal to the average wage, bonuses, benefits, and indemnities, including the value of benefits in kind, but excluding reimbursement for expense, that the worker earned during the 12 months preceding the date of departure on leave. This allowance shall in no case be less than the allowance that the worker would have received had he actually worked. Article 169, the length of continuous service set out in Article 166 must cover the entire period during which the worker has a labor contract with the employer, even if the work was suspended without a termination of the contract. Included in the period for which the worker is entitled to paid leave each year is as follows: weekly time off, paid holidays, sick leave, maternity leave, annual leave and notice period. Special leave granted up to a maximum of 7 days during any event directly affecting the worker's immediate family. On the contrary, special leave for personal reasons is not included when calculating the eligibility period for paid annual leave if the time off was not made up. Article 170, in principle, annual leave is normally given for the Khmer New Year unless there is a different agreement between the employer and the worker. In this case, the employer must inform the labor inspector of this arrangement. In every case of the paid annual leave exceeding 15 days, employers have the right to grant the remaining days off at another time of the year, except for the leave for children and apprentices less than 18 years of age. Section 7, Special Leave, Article 171. The employer has the right to grant his worker special leave during the event directly affecting the worker's immediate family. If the worker has not yet taken his annual leave, the employer can deduct the special leave from the worker's annual leave. If the worker has taken all his annual leave, the employer cannot deduct the special leave from the worker's annual leave for the next year. Hours lost during the special leave can be made up under the conditions set by a Prakas of the Ministry in charge of labor.